If I may, we can't stipulate to the amount, so we would have, at the very
That's why
least,
you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, 24 CR 011624, State versus Jan Hawkins, AKA Jan Madura. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay. Is my understanding.
Okay, because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. We are waiving count 1. We're proceeding on a lesser included of count 2
And what are you proceeding on?
a Class A theft.
No objections, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that you defer deportation before a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
Right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here?
Well, I am going to ask to a restitution hearing.
Okay.
And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So you all will have to correct your paperwork.
Judge, if I may,
Mhm.
we've done this before. We are
Not
pleading
with
no.
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provide purpose having us do. We've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the junior league.
Well, Judge, she doesn't have to stipulate to it. She's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession, but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have, at the very
That's why you have, nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well, that's where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this. If she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then you all
amount.
need to change your paper.
And Your Honor, I know to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true
I can't do any of that if y'all are not stipulating to anything, then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
There's
thing.
no
I haven't read any of the evidence, so I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody's stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount, so we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank
Jason, your hand, you're outside of mine.
For the defense? Defense.
On the record, your name. Oh, Bob Hicks.
And are you Amanda Drummond?
Yes, ma'am.
All right, you entered a plea bargain agreement. And according to the plea bargain agreement, the state is recommending deferred adjudication. You're charged with possession of a controlled substance penalty group 1 gram to 4 grams. The court ordered a TAP evaluation before sentencing based upon what I reviewed in the stipulations. Have both parties had a chance to review the TAP evaluation state?
Yes, sir.
Defense?
Yes, Your Honor.
Any objections to the TAP evaluation?
Nothing from the state law. Nothing from the defendant.
All right.
She seems to be highly motivated for treatment.
All right. Anything you wish to say on behalf of your client?
Well, Judge, according to the TAP evaluation and the Tacoma evaluation, she has had a pretty rough life, part of which is occasioned by her drug problems.
Mhm.
And part of which is the fact that her family has basically disowned her. She
And I'm
does
sorry,
have-
just one moment. And state you may be excused.
Thank you, Judge.
All right, you may continue.
She has a friend who is pretty much her sole support.
Mhm.
And she, as it says in the TAP evaluation, is very high. She wants treatment. She knows she's not going to be able to kick this stuff on her own, especially given what she was using, which was heroin daily, meth daily, and a phenomenal amount of alcohol daily. And The materials provided indicate that she is recommended for treatment and she is eager to take that treatment.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right, make sure you keep your voice up so that the court reporter can hear. All right. So do you have any children?
I do, but they're all grown.
Okay. All right. You're not going to be released today because what I'm going to order is, Miss Abrams, I'm unaware. I don't know if felony drug court has started openings or no. All right. All right. So this is what I'm going to do. Because one, the reason why I ordered the TAP evaluation is I want you to be successful in this probation. And I see that there are some drug issues that are happening. So we want to make sure that you have all the tools you need to be successful. In this courtroom, to be successful on probation, communication is key. If you ever feel as though you want to use or life is just hitting you and knocking you down, you can pick up the phone and call your probation officer and tell them, hey, I think I'm going to use. This is what's happening in my life. They're not going to send me a violation report saying revoke her. All violation reports come to me. And sometimes I will have compliance hearings where I have people come in to say, hey, what's going on? So I can hopefully get you back on track. And of course, there are some things that I can't get you back on track if somebody picks up maybe a violent offense. You know, I keep an open mind about everything, but for that, maybe I'm just going to sign a motion and say, hey, motion to revoke. But if there's an issue with your drug use, which is what we're trying to address, you got to do your part and we'll do our part. Okay. So what I'm going to do, Miss Abrams, in this case, I'm going to place her on probation, 6 years deferred adjudication. Here's the thing about that 6 years deferred adjudication. If you complete everything early and you're doing great, the probation will send me a notice saying, hey, can you let her off probation early? She's got everything under control. She's doing great. And if that's the case, then I'll probably let you off early. You understand? So even though I'm saying 6 years deferred adjudication, whether you're on for 6 years or not is completely in your control. There's going to be regular reporting by Zoom or in person. That means you have to report. And usually it's once a month. All right. If you need to report more than that because you're trying to stay on track with your sobriety, just let probation know. They'll make adjustments. Okay. There's going to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. So you can get a job, but not as a babysitter, or you can't babysit. You can't work as a home health care provider. Okay. There's going to be regular random UAs. And the UAs is where they test you for drug use. Okay. I'm going to want field visits 1 time per month until further notice. Now, felony drug court is a great program. They're not going to be available to even consider accepting you till the beginning of February because of funding. I always tell everybody, talk to your legislature about getting them funding. So, Ms. Abrams, we're going to do a referral to felony drug court. And then I'm going to follow the recommendations of TAP evaluation. I want felony drug court first because they'll be able to address the drug issues plus the mental health issues. But we can also do a referral to DDRF, which is what they're recommending. If for some reason she's not accepted into that and she can't get into felony drug court, we'll bring her back and we'll consider another placement for you. Okay. I just don't want you out in the world with not any support. I'm going to want 120 sober meetings and 120 days upon release. And let me just see if there was anything else that was asked in your plea bargain agreement. All right. Probation. Is there any, there's going to be 200 hours of community service restitution. Do you have any grandchildren?
I have one.
And what's their age?
She's 2.
All right. And are you in contact with your family?
I have contact with them.
All right. So let me just tell you, sometimes people want people to babysit. You're not in the condition yet to be babysitting, right? But what I will do is I'll deduct 100 hours of your community service restitution. And I'm going to order that you complete parenting classes. That's to help you when you are clean and sober and you want to be around your grandchildren. How far did you go in school?
10th grade.
All right. And then I'll do another 100 hours if you obtain your GED or some sort of trade school certificate. So I believe that community service hours, sometimes helping the community, is you getting your GED, you getting good, stable employment. So you need to complete your parenting classes. I'll deduct 100 hours off of that. And probation, if she obtains her GED or trade school, that'll be another 100 hours. If you don't want to obtain your GED or in some sort of trade school, then you're going to have to do 100 hours of community service. And sometimes that means picking up trash off the highways and byways. You understand? Yes.
I've been to a trade school. I have my CDL.
Okay.
So, I mean, I've already been to trade schools before.
All right. Well, I tell you what, if your license is in order and you present that to probation, then I will deduct 100 hours of community service restitution.
Okay.
All right. Probation, is there anything else? I'm sorry, what? Yes. And MIC supervision. And that's a specialized caseload so they can address any issues you have. Anything else, probation? Is there anything else you need from the court in order to be successful?
No,
I'm sorry, Judge.
Yes.
I apologize. Mr. Hicks mentioned that she lived in Karnes County.
Ah,
She lives in Karnes County. However, she understands that she's going to need to live here until.
all right. So are you okay with living in Bear County? All right. So she's okay with living in Bear County. All right. So counsel, I need your client to sign the trial court certification of defendant's rights to appeal.
I didn't do this before. And where it says defendant. I got you there.
right here.
Yes.
Thank you.
That
All right.
explains why I didn't sign any of those before. Actually, I did. I
Oh.
have one.
All right. Did you review the document with your attorney? It's called Trial Court Certification of Defendant's Rights to Appeal. It's this document
Yes.
that you just signed.
Yes, ma'am.
Did you review that with him?
Yes.
Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. We can go off the record. In this court, as I said before, communication is key. If there is an issue, let your probation officer know. If you feel that they're not addressing it, if the courthouse is open, I'll be here. You can come in and address it with me, okay? All right, if you need anything, let us know, all right? You're welcome. Probation is going to go over conditions with you. Thank you,
Thank you.
Mr. Hicks.
A self-proclaimed sovereign citizen appears in court believing the law doesn't apply to him, but his arguments quickly fall apart under the judge's questioning. After repeatedly refusing to cooperate and ignoring legal procedures, the judge delivers a decision that leaves him facing serious consequences. The courtroom exchange serves as a reminder that rejecting the court's authority can make a difficult situation even worse.